Hello friends, today we are going to discuss administration of the Act and rules. Administration of the Drugs and Cosmetic Act and rules are divided into three parts. First is administrative part, or we can say advisory part. In that, A. DTAB, Drug Technical Advisory Board, and second one DCC, that is Drug Consultative Committee. Second part is analytical part. In that, first Central Drug Laboratory CDL, then B. Drug Testing Laboratory of the state, C. Government Analyst. Third part executive part. In that, first Controlling Authority, second Licensing Authority, and third Drug Inspector. Now we are going to see first administrative part, or we can say advisory part. In that, first DTAB, that is Drug Technically Advisory Board. The following are the members of Drugs Technical Advisory Board. We have to remember here 8 members are there, ex officio members. Just remember 2P and 6D. 6D, in that first D is Director General Health Services, who is the chairman of that committee, that is DTAB. Then Drug Controller of India, then Director of CDL, that is which is situated in Kolkata, then Director of Central Research Institute, Kasoli, then Director Indian Veterinary Research Institute, Nagar, then Director of Central Drug Research Institute, CDRI, Lucknow, then President of PCI and President of MCI. It is very easy to remember. Just remember 6D and 2P. 6D are all are 5 in 6D. 5 are directors. One is Drug Control of India. First director is Director General Health Services. Then Drugs Controller of India. Then Director of CDL. Director of CRI. Then Director of Indian Veterinary Research Institute. Then Director of CDRI. Then President of PCI and President of MCI. These are the ex officio members of DTAB. Then second, nominated members. In the nominated members, just remember 2, 1, 2. 2 persons nominated by central government who are in charge of drug controls in state. Second, 1 person from the pharmaceutical industry nominated by central government, and 2 government analysts nominated by central government. All these three members are nominated by central government only. You have to just remember 2, 1, 2. 2 persons two persons who are in charge of drug controls in states, 1 person from pharmaceutical industry, and 2 government analysts nominated by central government. And third, elected members. A teacher in pharmacy or pharmaceutical industry or pharmacognosy of an Indian university or an affiliated college elected by the Executive Committee of the Pharmacy Council of India. Second member, also a teacher in medicine or therapeutics of an Indian university or an affiliated college elected by Executive Committee of MCI. One person elected by the Executive Committee of PCI, and another person, that is here a teacher in pharmacy, it is elected by the Executive Committee of PCI, and teacher in medicine or therapeutics, it is elected by Executive Committee of MCI, that is Medical Council of India. Then third, pharmacologist, which is elected by the governing body of ICMR, that is Indian Council of Medical Research. Then 1 person elected by the Central Council of Medical Association, and 1 person to be elected by the Council of Indian Pharmaceutical Association. Next, the nominated and elected members hold the office for 3 years. They are eligible for renomination or re-election. Then next is the function of DTAB. The board advises the central government and the state government on the technical matters arising out of the administration of the Act. Then it advises the central government in framing and modifying the rules under the Act related to import, manufacture, sale, and distribution of the drugs. The next, the central government appoints a secretary of the board and also provides a clerical and other staffs. The board may constitute subcommittees and may appoint persons to such subcommittees who are not the members of the board for the consideration of particular matters. There is separate Ayurvedic and Unani DTAB, that is Drug Technical Advisory Board, constituted under section 33C of the Act. The next is the DCC, Drug Consultative Committee. The central government may constitute an advisory committee to be called the Drugs Consultative Committee to advise the central government, the state government, and the Drug Technical Advisory Board on any other matter tending to secure uniformity throughout India in the administration of this Act. We have seen in the DTAB, the function of DTAB is to advise the central government and state government, and in DCC will advise central government, state government, and also the DTAB. Now the constitution of DCC, it consists of 2 representatives of the central government to be nominated by that government and 1 representative of each state, government to be nominated by the state government. There is also separate the Ayurvedic, Siddha and Unani Drugs Consultative Committee constituted under section 33D of the Act. Then next, the functions of DCC. The committee advises the central government, then state government, and also the DTAB on any matter to secure uniformity throughout the India in the administration of this DNC Act. Second part is analytical part. In that first, CDL, that is Central Drug Laboratory, which is situated in the Kolkata. The central government established a central drug laboratory under this Act. The director of the central drug laboratory is appointed by central government. The different types of samples are tested in different laboratories, which are working on behalf of CDL Kolkata. Main CDL is situated in Kolkata. Types of samples to be tested, for example, sera, vaccine, toxins, antigens, antitoxins. These are laboratory where tested. The Central Research Institute Kasoli, then anti-sera, vaccine, toxoids, and diagnostic antigen, all veterinary use, all for the veterinary use, which is tested in Veterinary Research Institute, which is situated in the Ijatnagar. Then samples of condoms, Central Pharmacopoeia Laboratory, Ghaziabad. Then sample for oral polio vaccines, National Institute of Communicable Diseases. Then samples of VDRL antigen, the Laboratory of Serology and Chemical Examiner to the Government of India in Kolkata. Then functions of CDL. First function is to analyze or test the sample of drugs and cosmetics sent it by the custom collectors. Then second, to carry out other duties given by the central government or state government or DTAB, that is Drug Technical Advisory Board. All the test reports of the samples shall be sent under the register post in a sealed packet with a memorandum form number 1. Next, the drug control laboratories in the states. Every state has a laboratory for analysis and testing of the drugs and cosmetics manufactured or sold or to be sold within that respective areas. Samples sent by the drug inspector are analyzed in these laboratories. These laboratories may also test or analyze the sample of drugs sent by the purchaser of a drug on payment of specified fees prescribed in Schedule B. Next, the government analyst. A government analyst appointed by the central government or state government under section 33F in case of Ayurvedic, Siddha and Unani drugs, and under section 20 in relation to other drugs and cosmetics. The state government may, by notification of the official gazette, appoint such a person as it thinks fit and having the prescribed qualification to be the government analyst for such areas in the state and in respect of such drugs as may be specified in the notification. The central government may also appoint such a person as it thinks fit having the prescribed qualification to be government analyst in respect of such drugs or as may be specified in the notification. Notwithstanding anything contained in subsection 1 or subsection B, means this subsection 1 and this subsection 2, neither the central government nor a state government shall appoint as a government analyst any official not serving under it without the previous consent of the government under which he is serving. Then, no person who has any financial interest in the import, manufacture or sale of drugs or cosmetics shall be appointed to be as a government analyst under section 1 or subsection 2 of this section. Then next, qualifications of government analyst. It should be a graduate in medicine or science or pharmacy or pharmaceutical chemistry of a university established in India by law or has an equivalent qualification recognized or notified by the central government and had not less than 5 years postgraduate experience in the testing of drugs in a laboratory under the control of first, a government analyst, second, the head of an institution or testing laboratory approved for the purpose by the appointing authority or has completed 2 years training on testing of drugs, including the items stated in the Schedule C in CDL. Next, it should possess a postgraduate degree in medicine or science or pharmacy or pharmaceutical chemistry of a university established in India by law or any equivalent qualification which is notified by the central government and possess the associateship diploma of the institution of the chemist obtained by passing the said examination with analysis of drugs and pharmaceuticals as one of the subject. Means one subject should be analysis of drugs and pharmaceuticals and with not less than 3 years experience in the testing of drugs under the control of first, a government analyst, and second, the head of institution. The next, functions of government analyst. We have seen the qualification of government analyst. Now we are going to see the functions of government analyst. The government analyst to whom a sample of any drug has been submitted for test or analysis shall deliver to the inspector submitting it a signed report in triplicate in the prescribed form. Then the inspector on receipt shall deliver one copy of the report to the person from whom the sample was taken and shall retain the third copy for use in any prosecution in respect of the sample. Then any document purporting to be a report signed by a government analyst under this chapter shall be the evidence to the facts. Then such evidences shall be conclusive unless the person from whom the sample was taken has within 28 days of the receipt of a copy of the report. Then unless the sample has already been tested or analyzed in the CDL where a person has under subsection 3 notified his intention of adducing evidence in contravention of the government analyst report. Then the cost of the test or analysis made by the central drug laboratory under subsection 4 shall be paid by the complainant or accused as the court shall direct. Means court will decide who will pay the fees, complainant or accused person. The next third part is executive part. In that, first one is the controlling authority. All inspectors appointed by the central government shall be under the control of an officers appointed in this behalf by the central government. All inspector appointed by the state government, same. All inspectors appointed by the state government shall be under the control of an officer appointed by in this behalf by the state government, here central government, here state government. For the purpose of these rules, an officer appointed by the central government under sub rule 1 or as the case may be an officer appointed by the state government under sub rule 2 shall be a controlling authority. The next, qualification of a controlling authority. No person shall be qualified unless he is a graduate in pharmacy or pharmaceutical chemistry or medicine with the specialization in clinical pharmacology or microbiology from a university established in India. Then he has experience in the manufacture or testing of drugs or enforcement of the provisions of the Act for a minimum period of 5 years. Provided that the requirements as to the academic qualifications shall not be applied to those inspectors and the government analysts who were holding those positions on the 12th day of April 1989. Then next, B, that is licensing authority. No person shall be qualified to be a licensing authority under the Act unless first he is a graduate in pharmacy or pharmaceutical chemistry or in medicine with specialization in clinical pharmacology or microbiology. Then he has experience in the manufacture or testing of drugs for minimum period of 5 years. Then provided that the requirements as to the academic qualification shall not apply to those inspector and the government analyst who were holding those positions on the 12th day of April 1989. Same like controlling authority. The next, drug inspector. The central government or state government by notification in the official gazette appoints inspectors having prescribed qualification under section 21 of the Act for the specified area. A person to be appointed as a drug inspector should have no financial interest in the import, manufacture, sale of the drugs or cosmetics. Drug inspector is a public servant under section 21 of the Indian Penal Code, IPC. Next, the qualifications. A person appointed as a drug inspector should possess the following qualification. First, it should be graduate in pharmacy or pharmaceutical sciences or medicine with the specialization clinical pharmacology or microbiology. Then, or not less than 18 months experience in the manufacture of at least one of the substances specified in the Schedule C, or not less than 18 months experience in testing of at least one of the substances specified in a Schedule C in a approved laboratory. Then not less than 3 years experience in the inspection, not less than 3 years experience in the inspection of firms manufacturing any of the substances specified in Schedule C. Then provided further that a requirement as to the academic qualification shall not apply to persons appointed as an inspector on or before 18th October 1993. Next, powers of the drug inspector. Within the local limits for which the inspector is appointed, we are going to see the powers of drug inspector. First, they inspect any premises wherein any drug or cosmetic is being manufactured, and also he may inspect the means employed for standardizing and testing the drug or cosmetic. Means he can anytime inspector can inspect the premises. Any premises wherein any drug or cosmetic is being sold or stocked, then he can take the sample of any drug or cosmetics which is being manufactured or being sold or stocked from any person conveying, delivering or preparing to deliver any drug or cosmetic to a purchaser or consignee. Then third, search. He search any person in connection with the offense under this chapter at all reasonable times. Then fourth, enter and search. At all reasonable times, any place or premises in which he has reason to believe that an offense is being committed or has been committed. Then stop and search. Any vehicle which he has reason to believe used for carrying any drug or cosmetic in respect of which offense has been or has been committed. He can stop any vehicle and search. Is there any drug or cosmetics there? Then 6. Give order. In writing to the person in possession of drug or cosmetic in respect of which offense has been committed or is being committed, not to dispose stock of such drug or cosmetic for a specified period not exceeding 20 days, or unless the defect may be removed by the possessor of the drug or cosmetic, and may seize the stock of such drug or cosmetics or substance or article employed for the commission of offense. Next, examine any record, register, document or any other material object found while exercising above powers, and seize the same if he has reason to believe that it is an evidence of the commission of the offense under this DNC Act. Then exercise any other powers as may be necessary for carrying out the purpose of this act and the rules made thereunder. We have seen the powers in that. First one is the inspect, then second take samples, third search, then enter and search, then stop and search, then give order, then examine, then exercise. These are the powers of inspector. Then duties of drug inspector. We have seen the powers of drug inspector. Now we are going to see the duties of drug inspector. The duties of drug inspector are conveniently grouped as follows. First one is the duties in relation to the sale of drugs and cosmetics, and second one in relation to the manufacture of drugs and cosmetics. First one is the sale, related to sale, and second is related to manufacture. Now we are going to see the first duties in relation to the sale of DNC. Subject to the instruction of the controlling authority, it shall be the duty of inspector first to inspect at least once a year all establishment licensed for sale of drugs in the area assigned to him, and to satisfy himself whether the conditions of the licenses are observed or not. Then, if he thinks necessary, to obtain and send the samples of imported drugs and cosmetics for test or analysis, which are being sold, stocked in contravention to the provisions of this DNC Act. Then, to investigate any complaint in writing made to him. The next, to institute prosecutions in case of breach of the DNC Act and rules. To maintain the records relating to all inspections and action taken by him, and to submit copies of such records to the controlling authority. To make inquiries and inspections regarding the sale of drugs in contravention of the Act. Then next, to detain the imported packages if he suspect to contain drugs the import of which is prohibited. The next, duties. We have seen the duties in relation to the sale. Now we are going to see the duties in relation to the manufacture of the drugs and cosmetics. To inspect at least once a year all premises licensed for manufacture of drugs within the assigned area. Then to inspect premises licensed for a manufacture of drugs specified in Schedule C and C1 and to observe process of manufacture. Then to send after each inspection a detailed report of inspection to the controlling authority. Then to take sample of drugs manufactured on the premises and send them for test or analysis. Then to check all the records and registers required to be maintained under the rules. To institute prosecutions in respect of the breaches of the BNC Act rules. And next, procedure of inspections. Section 23, 25 and Rules 57. First A, for taking samples of drugs for analysis and their dispatch to the government analyst. Where an inspector takes any sample of drug or cosmetic, he shall first intimate the purpose to a person from whom he takes the sample in writing in a prescribed form, that is form number 17. Then tender fair price of the sample and obtain acknowledgement thereof. If price is refused by such person, he has to tender receipt thereof in prescribed form, that is 17A. Then divide the sample in the presence of such person in 4 parts unless the willfully absents himself and effectively seals and mark the portions so sealed. Then if a sample is taken from manufacturing premises, it should be divided in only 3 parts. Further, if a drug is packed in small volume containers or gets damaged or deteriorate on exposure, 3 or 4 containers to be taken as the case may be and sealed or marked. Next, restore one portion or container with a person from whom sample is taken. He has to restore one portion or container with a person from whom sample is taken. Then send one portion to the government analyst for test or analysis by register post or by hand in a sealed packet. Then reserve one portion for production before the court if proceedings are instituted in case of such sample. Then send remaining portion to a person whose name, address and other particulars have been disclosed under section 18A. Every person not being manufacturer or his agent if so required. Then for seizure of stock. Whenever inspector suspect that any drug or cosmetics contravenes any of the provisions of this DTAB Act, he may seize any stock of such drugs or records, registers, documents which are believed to be evidence of the commission of an offence, and he should inform to the judicial magistrate as soon as possible and take his order for the custody of the same. Then if the alleged contravention by such that defect may be remitted by the possessor and inspector on being satisfied, he can revoke his order and may return the material to possessor. Next, penalty for obstructing inspector. If any person willfully obstructs an inspector in the exercise of the powers conferred upon him or refuses to produce any record, register or any document when required, he shall be punishable with imprisonment up to 3 years or with fine or with both. Then reports of the government analyst. On receipt of sample from inspector and on completion of analysis or test, government analyst sends a signed report in triplicate in prescribed form. The inspector on receipt of reports from government analyst delivers one copy of the report to the person from whom the sample was taken. One report to the person from whom the sample was taken and another copy to the warrantor if any, and reserves the third copy for use any prosecution in respect to the sample. Means we have to provide 3 reports. First one to the person whom the sample was taken, second to the warrantor, and third one for use in any prosecution with respect to the sample. Then the report signed by the government analyst taken to be evidence of the facts, and it is considered conclusive unless challenged within 28 days of the receipt of the report by a person from whom sample is taken. Means anyone can challenge the decision within 28 days. If such report is challenged, then sample of such drug or cosmetic is sent to the CDL by court and the report signed by the director CDL is considered final. Got it? Thank you.